Good morning. It's February the 18th. I'm Teddy, and you are listening to Messy Mocha. I'm going to try to do this for maybe 20, 30 minutes. I don't know. But right now, we're going to listen to some music, and I will be right back.
Não é só na vida que a vida não é na janela que se olha. Há uma linha clara perto da saída. Fecha os olhos e você vai ver. Não é só aqui que sol ilumina. Coisas do além que vão além. Quando de repente é coincidência, nem precisa se esforçar pra crer. Apagaram as luzes pra eu ver. Saí da onde vim pra eu poder ser. Você mostrou o caminho pra eu andar. Eu disse é pelo mar que eu vou nadar. Não é só na vida que a vida não é na janela que se olha. Há uma linha clara perto da saída. Fecha os olhos e você vai ver. Não é só aqui que o sol ilumina. Coisas do além que vão além. Quando de repente é coincidência, nem precisa se esforçar pra querer. Apagaram as luzes pra eu ver. Saí da onde vim pra eu poder ser. Você mostrou o caminho pra eu andar. Eu disse é pelo mar que eu vou nadar.
All right. It's Wednesday. And you know what? I'm still a little congested, but I'm doing better, and I have to just take it moment by moment. Last night I did not come on. It was late. I was working on something and did not want to break away from it. But I wanted to come on this morning and let everyone know that thank you for your support. Thank you for the emails. Thank you for the encouragement, and thank you for being here. So grab your cup. Let's sip this morning mocha up. I see Survivor, V Love, Survivor 1, official good morning to you and some others that are in the chat. I've changed my background here just for a moment, just to change it up. That's West 10, West 90, somewhere in Lake Charles, Louisiana. Yeah, so that's that big bridge. And, I have others. There's something there's something that I have come across. Yeah. And people have asked, different people have asked questions about, eh, what happened and what, was the story and all of that. But right now, my focus is on a specific time frame of events that occurred between December the 23rd, 2023, and December the 23rd, 2024, when I filed the lawsuit. All right. Again, I have to take this moment by moment. I may have to pause and sneeze or whatever. Hang on. And I know every single time, whether I am on YouTube, whether I'm on Station Head, whether I post anything that I do, if it can be used to file to the court that they are looking for something that I say right now, because our upcoming deadline to respond to the report and recommendation is next Tuesday. All right. I believe that is, let me just look. I believe it's the 24th. It is Tuesday, the 24th. So that's where my focus has been. And I have read through ECF 138 at least a couple of times. And as a reminder, the magistrate judge, in my case, that's Judge Stafford, narrowed what was the remaining claim. And she put that as Lara and the claims that were filed to Lara. Okay. And that is the medical board here in Michigan. Let me just tell you. Let's look it up. Lara, Michigan. So that you know, it's the licensing and regulatory affairs. All right. And Lara is responsible for a number of things. The Michigan Department of Licensing and Regulatory Affairs. It's not just for PAs, but it's for any licensing related here in Michigan. And they have a website, and it's where the defendant and others filed their initial complaints and subsequent complaints to this licensing and regulatory affairs. Okay. The first one was filed September the 12th of 2023. And the magistrate judge is basically said that one, because it was argued as time barred, and because there is a specific rules, all right, here in Michigan related to when defamation is considered within the limitations, all right? And there's a 1 year rule. And because that one is outside of the um, time frame that I filed, that one should be dismissed or not included. All right. That's just one of the recommendations. That's what it is. It's a report and recommendations based on arguments that were made by the defendant to dismiss the case. ECF 77 was argued and ECF 127. Again, I'm not looking at any of those documents. I'm just, hang on, I am trying to pull it. All right. So just a second. Let me play some music. I'm just going to read a part of it. So hang on. All right, so I pulled a certain section and I'm not going to show it, but let's just switch. Let's switch this up back to this. And I will tell you what I'm reading from to let you know where my focus is. One of the things in ECF. I'm just going to read a couple of sections. And this is ECF number 138, page ID, beginning at 3074. This one was filed by the magistrate judge in the report and recommendations. It begins by saying Robertson and Williams also allegedly filed lyric complaints against Evans to get her physician assistant's license revoked. ECF number 1, page ID 11. The exact substance of the lyric complaints is unknown, as Evans lacks access to the communications. But Evans alleges that Robertson made an earlier lyric complaint alleging malpractice, and that the later complaints were part of the same campaign of making baseless accusations aimed at revoking her medical license. Page ID 9 through 11. And Lara's response letter stated that the department would investigate whether Evans violated the public health code. Page ID 58. Thus, the allegations support an inference that Robertson and Williams accused Evans of malpractice. Defamation claims may be premised on false accusations of medical malpractice. That was in the case of LL New Jersey Incorporated versus NBC subsidiary WCAU TV LP. That was published in 2008 in Westlaw, Michigan, April 28th, 2008. See also Swinson, Davis, and Martell. Defamation per se exists when the statements are false and malicious and are injurious to a person in his or her profession or employment. Robertson contends that the lyric complaints cannot sustain a defamation claim because they are privileged. ECF number 77, page ID 985. Michigan law recognizes a qualified privilege as applying to communications on matters of shared interest between parties. Rosenboom, Van Eck, 451, that was published in Michigan Circuit Appeals, 1989. The privilege extends to all bona fide communications concerning any subject matter in which a party has an interest or a duty owed to a person sharing a corresponding interest or duty, including moral and social obligations. The privilege applies to a report of medical malpractice to a state regulatory agency. That was from Nguyen versus Slater, Michigan, 1964, involving a nurse's claim that she was defamed in a letter accusing her of misconduct sent to the state health department. A party claiming defamation may overcome a qualified privilege only by showing that the statement was made with actual malice. That's Knutson versus Gazette, Michigan Court of Appeals, September 14, 2023, and in Michigan Court of Appeals in 1992. Actual malice means knowledge that the published statement was false or as reckless regard as to whether the statement was false or not. Evans alleges that Robertson submitted baseless lyric complaints in a malicious attempt to get Evans' professional license revoked. ECF number 1, page ID 11. Taking this allegation as true, as the court must rule 12b-6, Evans has plausibly alleged facts showing that the privilege does not apply. So the defendant was arguing that she had privilege. Okay. Next, Robertson also argues that Evans is a limited purpose public figure and so must plausibly allege that the defamatory statements were made with actual malice. ECF number 77, page ID 989. Statements about public figures are entitled to qualified immunity that can be overcome only by a showing of actual malice. That's New Franklin Enters versus Sabot from Michigan Court of Appeals, 1991. A private person can become a limited purpose public figure when he voluntarily injects himself or is drawn into a particular controversy and assumes a special prominence in the resolution of the public controversy. The pleadings do not show that the lyric complaints became a matter of public controversy. There is no sign that the complaints garnered public interest or press coverage. CID, besides, Evans has sufficiently alleged facts supporting actual malice as discussed above. Footnote 5. Robertson asserts two other cursory arguments that the court declines to address. First, she argues that the defamation claims must be dismissed because Evans self-published certain statements. ECF number 77, page ID 990. But she does not identify the statements or connect them to the allegations in the complaint. Second, she argues that the strategic lawsuit against public participation statute, commonly known as the Anti-SLAPP Act, shields her from suit. ID page ID 991 90 through 991. But she cites no state's anti-SLAPP statute and offers no analysis about the application of the statute in federal court, issues a verdict to in a perfunctory manner, unaccompanied by some effort at developed argumentation, are deemed waived. McPherson versus Kelsey. And that was in the Sixth Circuit Court, 1997. Ann Robertson again challenges venue, making the same cursory arguments already considered, that she does not reside in, have substantial ties to, or conduct business in Michigan. ECF number 77, page ID 995. Venue for a civil action is proper in a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred. That's 28 USC 1391 B2. As concluded in the September 2025 report and recommendation, the claims over which court has personal jurisdiction are tied to Robertson's alleged acts targeting Michigan. And because Robertson does not offer substantive analysis showing the venue is improper, she has waived this issue. It's 10:04. I am trying my best to at least discuss some of which is in the report and recommendation. I hope that I can share more. But right now, I wanted to give you the opinion of why the magistrate judge ruled in my favor here now in the report and recommendation that the Lara complaints should move forward, those which are in the time between December 23rd, 2023 and December 23rd, 2024 when I file. That was the first one, 2023 in September 12th, on September 12th. However, there were subsequent filings that are recognized during that period. There were 9 additional complaints filed to the medical board. As noted, the magistrate mentioned, and this is paraphrasing, that the substance of those have not been revealed. That's my word. Okay? That's my wording. The complaints are with Lara. Okay? We have not began discovery. The defendant argued to stay discovery. We're not there yet. We are in this de novo period where objections to whatever was dismissed, whether it was argued by the defendant or myself, the plaintiff in this case, objections can be presented to the district judge on next Tuesday in a filing. Okay. And then once those objections are filed, if any, on either side, the time clock begins again in a 14-day period for each party to respond to the objection to the magistrate's objection to each other. And neither one will know what the objections are until they are filed on next Tuesday. So that governs this entire, 28-day period. Okay. But I wanted to give you at least one of the remaining that survived. Do I expect that the defendant is going to argue and object to the magistrate's finding to try to overcome that? I do. Okay. As she might have certain expectations. Okay. I am not going to, say what even her argument might be and or speculate on it in depth and or what my objections, if any, might be. I can tell you this. There are 9 claims, okay, that were filed to the medical board. Okay. And there is evidence of those filings. There is evidence of videos, posts linking to both parties who filed complaints. Okay. Much of that has been deleted from their websites, their social media, including YouTube. But this is one of the reasons why I maintain a presence, because had I not, I would not be sitting here today with verifiable, undeniable, not circumstantial evidence that support my argument and claims. Had I not preserved them, including letters from YouTube that demonstrate that I filed multiple privacy complaints during 2024 when videos were removed and re-upload it multiple times and put on 24/7 loops and played on various YouTube channels with the blue robe wellness check police footage, with the divorce documents, with the change.org petition posted, with substantial allegations and my picture put next to alleged criminals with their jumpsuits on, and filed, I'm going to say allegedly, to the Michigan Medical Board, LARA, alleging criminal behavior by myself, involvement in the unaliving, and boots on the ground and search for substantive harassment of multiple people in connection with all of these complaints, with malice, I would be sitting here empty-handed. I would be sitting here with my word against their word, their words. Because those things have been deleted and or hidden. People can say what they want about the librarian. And yes, I've been called the librarian. Mm-hmm. There's nothing wrong with that. If I didn't have the documentation, if I didn't gather the receipts and the recordings, it would be more difficult to show. And that's why the parties want this lawsuit dismissed. So we can't move into discovery, because it is within discovery that things will become clear. Okay? It's discovery. And I am committed to this the time that it takes to do the work. Whatever the time it takes. And I'm taking some time now just to come on, because I have missed, going on last night. I hope that you can continue to give me the space and the time that I'm going to need over the next several days. I will be checking in. I'm having, again, just to do these long pauses, because it's difficult to breathe and talk at the same time if something is blocked up or congested. But it's worth doing for now, just to let you know where things kind of stand. Okay. Mhm. There's much more that I can get into, but I need to um, leave it at that. All right. Um, there's a lot more that can be said about some other things in due time. In due time. But I am not the one who will get up here and boast and brag about outcomes that have yet to be finalized. This is a process. And I've been going through this process now, since December 23rd, 2024. I'm talking about the legal process. And I don't know what the end is going to be. But I know I am giving every bit of myself to do things properly, professionally, legally, lawfully, carefully, deliberately, however you want to put it. Because I know that traps and snares have been set. I know they're being set. And I know that my case, my lawsuit, is viable. It does have substantial information and things that were done to me. I am going to remain focused and moving forward. And I appreciate those of you who have stood by me and are there for me in whatever way it has been. I appreciate you. I appreciate my moderators for being there and encouraging me and helping me to remain focused during my broadcast. That's important. So that's going to do it for me for this morning. It's been 45 minutes. Thank you for the loyal supporters. Stay vigilant, everyone, and keep your bare phones on. Keep up with the post, and I will try not to wait to give you any notice if my schedule changes, so that you're not waiting up too late to for me to come on. All right, that's it. I have plans, but it might only be for a few minutes right now. Okay, so um, thank you for your time this morning. You can email me at unwindwithteddy@gmail.com. Let me just take a quick look. I'm good there. Thank you. Biggest bear hugs go out to all the grizzlies and the honey bears. Please hit the like on your way out. Don't forget to check out Run Tell That Too, and be prepared for broadcasts even on station head. Yes. I hope you have a great Wednesday. Thanks for watching. Until next time, I'm Teddy. Uh, good day.